Yes, welcome to the No State Project live from the fortified compound in San Bernardino, which is where I am for this big broadcast today. It's August 18th, 2018. If I'm getting the year over here, geez. Glad to be here. You're listening to the Liberty Radio Network, LRN.FM. And we have 3 hours of Anarchy Radio that we're doing over here. That's what we do every week. Well, most weeks. No, it's been it's been a week since we did the Saturday broadcast, but everything seems to be going pretty good so far. So we'll see how it goes. But thanks for tuning in, everybody. And I say Anarchy Radio, and I want to define what anarchy is, of course. Anarchy is no rulers. Imagine the radical concept of not having a ruling class. If you have a vested interest and you make your money on having a ruling class, then obviously you'd be for that. Because, of course, when you have such a vested interest, the money is a little more important than having any kind of principles. So, some people, it's all about the car that they have. It's all about the how many houses and how much money that they're making. Matter of principle, about fungal. That's what you do with your principles. We don't give a damn. So, we as anarchists, at least myself, believe that the rules should apply to everybody. That the basic principle of do no harm, live honestly, injure no one, give every man his due, should apply to everybody. And that leads me to, I guess, it kind of a tyranny spotlight, or just to show how the rules don't apply to everybody. So if anybody is still thinking that the rules don't really apply to the ruling class, we're going to talk about a Bedford, Pennsylvania attorney, a former prosecutor named William Higgins. And I know you can't really see his picture, so we're going to see. Well, hold on. There's the guy that we're talking about. This is the prick. And what this criminal did, William Higgins Jr. He was accused and pled guilty to abusing his power as a prosecutor to help female drug dealers in exchange for sexual favors. So what he was doing was he was courting them for sex and to go and give them lighter sentences. And he has been officially disbarred, is what this says. It's from wearecentralpa.com. No jail time. Now, because of the power dynamic, this man, this criminal, this lawyer, because of the power dynamic, basically have sex with me, or I have to throw the book at you and you're going to spend more time in jail. That is called rape. And this grotesque example, see if we get his face in there again. Can we do that? This grotesque example, hold on. This disgusting example of a human being, this piece of garbage, raped women, raped them, and is not doing any jail time. So don't anyone tell me that the rules don't apply to the special class for these henchmen, these useful idiots for the ruling class. Yeah, see, it's good to be the king. The man was a serial rapist, or is a serial rapist. No jail time. And he did plead guilty. I know a lot of people plead guilty to avoid trial because they're not actually guilty, but the pressure from pieces of garbage like William Higgins Jr. caused them to do that. But I'm not thinking that's the case over here. No friggin' jail time. Yeah, he was sentenced to $9,700 in fines and 8 years of probation, 1,124 hours of community service, 120 days of house arrest, and was sentenced for counseling. A serial rapist. Serial rapist. Who knows? I don't need, I had to take a look and see just how many women he raped. What's surprising is that he was actually charged at all. The fact that he was actually charged, that's a surprise. I'm not surprised he received no jail time, because that piece of garbage, Ken Anderson, who sent an innocent man to prison, knowing that he did not kill, he knew the guy was completely innocent. Anyway, he sent him to 25 years in prison. He did 5 days. This SOB got less time than, well, he got no time. There are people like Bao in Texas that got 10 days for asking a question. Dick Noble and others up there in Detroit put Terry in jail for 60 days for asking a question. This guy is a serial rapist. No time. Yeah. So don't anyone try to tell me that there isn't 2 sets of rules for these animals. Well, Mark, that's just one isolated incident. Well, let's talk about what, according to Judge Kaczynski, prosecutorial misconduct is at epidemic levels, and only judges can stop it. Epidemic levels. Now, prosecutorial misconduct in a lot of cases, just like with Stephen Myrie, and Ken Anderson, is as bad as rape. You're destroying somebody's life. And how many times has a lawyer done time? And how many times have any lawyers done time for prosecutorial misconduct, which is a felony? It's called obstruction of justice. Oh, that's right. Ken Anderson is the only prosecutor in history to be punished with any kind of jail time for prosecutorial misconduct. Yeah, you can have thousands of cases of it every year, and they go unpunished. So anyone tries to tell you that there isn't 2 sets of rules, that government, like prosecutors, lawyers, and judges and whatnot, that the rules actually apply to them and they get punished just as much as anybody else doing the same thing, they're lying to your face. Because here's one more example. My gosh, raping women. I will give you less of a sentence if you have sex with me. Jeez. Yeah, only the best and brightest. But at least they stripped him of his title of honorable. Yes, the Honorable William Higgins, Jr. Unbelievable. Wow. A state police affidavit said Higgins provided lighter sentences for women he was having sexual relations with, and provided names of confidential informants of at least 9 times, known to drug dealers or their friends, to protect them from prosecution on numerous occasions between 2014 and 2016. Wow. Following comments from several members of the community who criticized the Attorney General's plea agreement given to Higgins, Lincoln explained that removing a district attorney from office before conviction in Pennsylvania requires the action of the governor and 2/3 of the state Senate. Prosecution of that case could take 1 to 3 years, time that Higgins could have stayed in office and been paid without the plea agreement's resignation requirement. It's not a simple situation. Oh, yeah. Yeah. No, it is very simple. You have evidence of somebody being a serial rapist and abusing the office. You put him in jail. It's not a thing where if I was to do that, or if one of the plebes was to do that, well, it's a difficult situation. No, you arrest the son of a bitch. You put him in jail. What if he murdered somebody? If he actually killed somebody? Well, it's a difficult situation. It could take 1 to 5 years, 2 to 3 years to prosecute, and he would still be on the job. No, why don't you treat him just like you treat us? Just like if someone gets to he's being prosecuted for a traffic offense, and he just happens to go in, and he's called 15 minutes before lunch, and the judge didn't get laid that morning or the night before, and he's just in a foul mood, and he decides to hold him pending trial. No bond, no bail, nothing. So just another example of how it's good to be one of the King's men. We'll be back here on the No Stay Project in just a moment, so don't go away. And for those on the YouTube stream, remember, we are doing a live radio stream, so that's why we're going to go and mute out for just a few minutes. Yes, welcome back to the No State Project here on the Liberty Radio Network, LRN.FM. 3 hours of Anarchy Radio. You want to join me on the big show? It is 218-632-9399, 218-632-9399. Passcode is 2020 with the pound sign. And somebody's saying here, why do we keep getting this? Mark, let's talk about the part of our law that is never discussed, that we all chose to be governed. I can't say that that's just that all the time. All the time. You got to look at the facts. You got to look at what is the claim and what are the supporting facts, if any, that prove that the claim is true. So, we have to look at it critically. In a critical analysis, let's take the actual claim and let's see what facts and logic back that claim up. And the claim that people like to throw out is that, the people chose. The people chose to live here. And so if you chose to live in a certain part of Chicago, Al Capone's gang was there before you, so you must have chosen to be extorted by Al Capone and his boys. If you lived in certain parts of Brooklyn, Carlo Gambino and the boys, they were there first. So if you moved to Brooklyn and, or the Manhattan, one of the 5 families there, you're agreeing to be extorted. Now, you could say, well, yeah, that destroys the argument as far as the mafia, organized crime, but, this is government. It's different. Really? Well, let's take a look at facts. Facts are that when it was first set up till now, the people in that community, not ones necessarily that moved there, but the people in that actual community were forced just as much as we are today. It's a matter of you're going to have these services, and we have a prison system, and we have no problem at all using as much violence as is necessary to get you to comply. So, this idea that we chose to be forced to pay them doesn't really have any logic. No, it's just the facts say otherwise. Let the data speak whatever the data says. Men and women forcing other men and women to pay them makes them criminals. Doesn't make them honorable. It makes them criminals. And so, no, we did not consent. Nobody consented. You had no choice. Well, you don't have to live here. Why don't you get the hell out of here? America! It doesn't matter where you go. They've taken over. There's no place to go. You used to be able, even when, what's his name? Henry David Thoreau, when he went to Walden, I think it was. It was still federal land or state owned. They still claimed it. There's no place to go. If someone breaks into your house, well, you stayed there. I don't know what to tell you, but just because Mr. Higgins, the serial rapist, broke into your house, the fact that you stayed there, this has to do with calling crimes out and actually sticking to your principles. They're criminals. If I force somebody to give me money, I'm a criminal. That's the way it is. So, and there's no merit to this nonsense that your parents could have consented for you. No, your parents weren't able to consent. Your grandparents weren't able to consent. You can look at like my familia. Well, it says right there, they became citizens. They had to be able to stay. It's this whole thing, you have no, because you'll have violent men and women that'll show you the door. So what do you do? All right. You got to, again, this whole show revolves around critical analysis. taking the claim and breaking it down, seeing what facts, what evidence are there to support it. And back, again, before I get to a caller, the fact is, this is not up for dispute. There are a few things in life that are not up for dispute. This is not up for reasonable discussion or dispute. Nobody had a choice. You either supported the government or you were killed in the process of getting your compliance. And usually killing a few people or destroying their property or just putting them into a cage was enough to get the rest to comply. So, what is the line from sheep? That's what you get for pretending the danger is not real, for not sticking up for principles. Okay, so look at the evidence. Look at the evidence, and it's dead set against any notion that it's consent. Like Lysander Spooner said, I'm going to say this for the critics: the only government by consent has been one at the point of a bayonet. That's the facts. That's the historical basis there. So. Anyway, let's get to the callers. Make sure. You see, I unmuted my board. We'll get to area code 510. You're live on the No State Project. What's your name? Where you calling from?
Mark?
Yeah, I'm here. What's your name? Where you calling from?
Oh, this is Grizzly Al from Northern California.
Oh, Al, it's good to hear from you again. Very important question before we get started. Okay, do you swear to, under penalties of perjury, to tell the truth while you're on the show today?
Kiss my what?
But do you swear to tell the truth during the show today?
I don't think so.
You're supposed to say no.
No.
Thank you. It's been a long time since I played that clip on the show. I'm going to have to try to find that during the break. But it's good to talk with you again. It's been a long time.
Well, thanks. That's my one-hit wonder.
Yes, that's right.
I called. I wanted to talk to you about the chat rooms. I think that on the chat rooms, you're getting people that aren't sticking with what you're teaching. One of the things that happened was when I was mentioning that you asked the facts question. What facts do you have that that your laws apply to me? And they were wanting to go to the merit. One guy wanted to go to the merits of the case.
All right. Well, hold on just a second, Al. Al, I'm sorry, I have to put you on hold, but we'll talk about the merits because there's a lot to get to on that. So just hold on for one moment. My name is Mark Stevens. You're listening to the No State Project here on the Liberty Radio Network, LRN.FM, and streaming live on my YouTube channel, which is No State Project. We'll be back in just a few moments. And if you are on the YouTube stream, remember, this is going to be a commercial break for a broadcast. So we'll get about 3 minutes. So that's why we had the silence. Welcome back to the No State Project here on the Liberty Radio Network, LRN.FM. Also streaming live on my YouTube channel, and the number is 218-632-9399 with the area code, with the passcode 2020 to get you into the queue. Right now, we're talking with Al, who hasn't been on the show in a while, who has had success with the process. Who was unfortunately prosecuted a while back. Welcome back, Al. And so you were talking about this is a big issue that you have, or that's been going on with the chat, among other issues, right, is discussing the merits.
Right. Well, discussing the merits of the case is almost acknowledging the jurisdiction, and that's where we don't want to go. So when you ask the facts question in there, you have to hold your ground and not be afraid of them. And that's what I find that people do when they're either discussing it in a chat. They're so afraid of what the judge is going to do that they don't stay on point. So the fear seems to overcome the logic of the idea of shifting the burden of proof. Because when somebody accuses somebody of something, to the accuser to prove their point. And so when, to give you an idea, I said to a researcher ago, I said, why don't you just have your client ask the court, what facts do you have that show that these laws apply to me? And the guy responds and says, well, I don't want to tear down the whole system. And when you think about it, the whole system doesn't have any authority. It only has authority by fear and the use of intimidation and violence.
Yeah, well, some would argue that jurisdiction is violence. That's when it comes down to it. It's power to act. Is it consistent and fair with due process and their own rules? Well, hell no. But anyway, I'm sorry.
But how do those rules, if they don't have jurisdiction, their court rules don't even apply to the person that's in the courtroom?
Well, I agree, absolutely.
Think about it.
I agree, and some may say, I saw one of the comments that my position is flawed because I case that they're criminals, but we still use their rules. I'm not saying we have to play by their rules. What I'm saying is, because it's certainly not an orthodox thing to challenge the applicability of the law, which is the foundation of their case and sets the relevance for everything. Everything. Nothing is relevant if they can't prove that their laws apply.
Exactly. I mean, anybody can violate a code, and we probably violate all kinds of codes every day that we get up in the morning. Well, but the problem is
but you can't. But Al, you can't violate a code if there's no evidence it applies in the first place. That's the big issue here.
You could violate it on its face, but if it's not applicable, it doesn't mean anything.
Right. And so the reason why I use their rules only when I need to is to just show that what they're doing is unfair. And a lot of times, which is really unfortunate because when in Rome, it is an extra hurdle if you point out that something is grossly unfair. They could even agree with you that it's unfair. But if you can't show them where in their law, where that particular example of being unfair is illegal or against their rules, they don't give a damn. Well, cite me the rule that shows that because somebody was saying, well, what rule says that prosecutors, can't argue without evidence? Cite me the rule. Well, it's 3.1 in the ethical rules, and you also have prosecutorial misconduct. So it sucks that you have to, in a lot of these situations, you have to cite that. It should just be sufficient, and whenever possible, I don't put citations in for everything. I personally don't think it's necessary. Make the point, this is unfair. So even if you don't have a particular citation, you can always use the general violation of due process. Due process requires that it's fair. And if you can show that it's not fair, then it violates due process.
Right, but if the laws don't apply, then anything they're doing in the courtroom is a fraud, and it's extortion.
Well, yes.
It's a big extortion racket.
Oh, exactly. But the thing is, when we're getting to and we're discussing the merits, I call them like traversing the merits. There's a time and a place to do that if it's actually necessary. Because if it's a code violation, very rarely in the situations that we deal with are the merits going to help you. I don't have a driver's license, let's say. They got me dead to rights. You know, so it's like if we go back in time a number of years where you can go back and you can listen to one of the a hearing that I did with Yeoman in Texas, where the hearing officer got a little bit perturbed with me, and she says, "Mr. Stevens, you're still not understanding this. This is that your client did anything wrong. This is about non-compliance with the code." I know.
Right.
I know that. And I'm showing that your witness has no evidence. Yeah, I'm saying your witness has and has not presented a shred of evidence so far throughout this entire proceeding to prove that these codes apply in the first place.
Okay, one of the most outrageous examples of going to the merits of the case was when I was doing my tax thing. And I can prove that the Internal Revenue laws were repealed in 1939. But do you think that anybody cared? Well, in the courtroom, they did not. They didn't care. But because if they were repealed, I mean, there's no point in doing any of this.
But they weren't charging you under the 1939 code or the 1913 code. They were charging you under probably the 1985 code. When it was, so what they do is they do this with traffic.
Yeah, but what they did was in the 1954 code was based on the 1939 code, which was repealed.
Yeah, but they
build a whole tax structure on top of the 1939 law that was repealed.
Well, it was repealed because it was replaced
according to their rules.
No, I don't know. I see. This is why I wouldn't argue something like that because they are.
I don't anymore.
That's good. Well, because whatever code they're happen to saying that you're violated, whatever year is attached to that, they still have to show evidence showing it applies in the first place instead of just assuming it, which is what they do.
Right. Right. And so what happens is if they actually tried to answer that coherently and showed how the law applied to you, then you could use the 39 code. Or another one is Title 18 was never lawfully passed by Congress, and they have a whole prison system built on it and a criminal law system based on something that was not. In other words, they don't even stick to their own rules.
Well, they never do. So whether that's true or not, it still doesn't get them out of the position or out of the burden of proof is on them. And if whatever claim that they happen to be making, they have to support it. It does
exactly.
But if someone's going to actually argue the merits, it should absolutely never be at the arraignment. The only time I would say that you would do that is if it's one of these minor charges where they're saying it was an equipment violation or something like that, or let's say they stopped you and you didn't have your driver's license on you, and then you could just simply unless you're an activist, then you could just go in and show the license. Okay. And you're arguing merits and the whole thing gets tossed out. Depends on why you're doing it. But most of the time with what we're dealing with, where pure code violations, they've got you dead to rights. The fact is you don't have a driver's license or you did not file a return. There's no ifs, ands, or buts about it. It's just that set of facts is not relevant yet. But we'll get to that in a moment. Let me put you on hold again. We're up against another project. We'll be back with Al in just a few minutes, so don't go away. If you are listening YouTube stream, we're going to have about 3 minutes, so please keep in mind we're doing a live radio broadcast, and that's why it goes silent for those few minutes. But we're going to talk about merits in just a moment. Yes, welcome back to the No State Project here on the Liberty Radio Network, LRN.FM. And let's see what we got there. Yeah, we should. Yeah, it looks pretty good. It should be sounding pretty good. So the mic shouldn't be hot anymore. But glad to be back with you here. We're talking with Al in California. So we'll unmute Al. So, but Al, just real quick before we jump back into this, because it's very important. I've said this before. I'll say it again. It's very, very important. When you are in court, specifically when you're in court, relevance is king. Nothing you are presenting is admissible if you cannot pass the minimum standard of relevancy. And something to be relevant to then be admissible or allowed to be discussed and admitted, for it to be relevant, it's a very, very low threshold. It has to have any tendency to prove the proposition. And you have two parts to their claim. They're claiming, one, the laws apply to you. And we're talking about police officers. We're talking about, prosecutors. We're talking about zoning officials, tax agents. They're all making these legal claims every single day. They're saying, and it's twofold. The first part is our laws apply to you, bitch, right? And then they say, yo, you violated them, okay? Okay, so that's the basis of their claim. And the second part, like we were talking about before, not having a driver's license, is that relevant? Does it have any tendency to prove that the proposition is true, that you violated the law, that the laws apply and you violated them? If there's no evidence that has been presented to show that the laws apply in the first place, if they can't support the first part of the claim, is anything going to the second part of the claim relevant?
No.
And if it's not relevant, is it admissible, or should it be admissible? Is it fair to admit it? According to their,
be admissible because there's no application of that particular piece of information because there's no jurisdiction.
Well, there's no jurisdiction, right? And there's no jurisdiction. But even if we're not just talking about jurisdiction, we're talking strictly the claim, the criminal charge or the claim against you, because there's no evidence of part one, which sets the relevance for part two. The fact that I don't have a driver's license is completely irrelevant because it has no tendency to prove the proposition's true. It can't, because it's not relevant. Because without the first part, not having a driver, it's just like whether the example I use is using steroids and being accused of violating the rules of the Olympics. If I use steroids, that would appear that on its face, I'm violating the rules of the Olympics. But there's not a shred of evidence to say that the rules of the Olympics apply in the first place. So whether I use steroids or not is completely irrelevant and so not admissible until they have some evidence to show the first part.
Right. Well, the Olympics I believe, is a private organization. So I suppose they can make the rules of the game a certain way so that it's fair. But in the government is imposed. All of this stuff is imposed on people by force.
Oh, sure.
And so, yeah. So it may be illegal to smoke a joint, but it doesn't mean it might be illegal, but it doesn't, if it's not hurting anybody, that's somebody else's choice whether they want to smoke that or not.
What we're getting to is whether, when we're discussing a straightforward, what we get 95% of the time, code violation, where the facts are not up for dispute. I didn't have a driver's license, or I didn't file a return. That's not up for reasonable dispute. And it's not something that I would risk disputing, because now we run the risk of going to jail for contempt or, lying in court. It doesn't happen to lawyers. They get to do that all the time. So that's why I'm breaking it down in this way. And relevance, again, is a very, very low threshold. But without the first part being done, the second part, nothing of the second part is relevant without that first part.
No, and unless they can prove that the laws apply. Anything else that happens in the courtroom is null and void. There's no substance to it. It's just all show, and they you know, when I was doing this stuff, it was called a steamroll, and that's exactly what they did. They just went ahead and did it by force.
Well, that's the name of the game. That's what they do. They use force. It all ultimately comes down to using whatever violence and threats of violence is necessary to get your compliance. You know, that's the way it is. But I want to make it clear that except in limited circumstances, there is no reason for us to be discussing the merits. So, for example, if you get into a cross-examination with a police officer who made the claims against you, and you're not permitted to, if the judge is not going to allow you to cross-examine the witness, and you cannot ask him questions on his prior statements, the fix is in. If the judge isn't going to allow you to cross-examine the witness against you, then I don't think any amount of exculpatory evidence on your side, you know, where you're arguing merits, I don't see how that's going to possibly help you, because the judge doesn't give a damn. And we've heard time and again people call the show and say, well, the judge wouldn't allow it. And what the judge will do too, or the prosecution, they'll argue relevance, and that what you're trying to put in is not relevant. And even if you can show it has a tendency to prove, again, it's a very low threshold. Yeah. You and I, we can show that it has a tendency and should be allowed. The judges don't allow it. So,
if you remember James Back's case, he was not allowed to use the whiteboard.
Right. But the whiteboard, but that's not the whiteboard wasn't being used so that James was trying to enter evidence and discuss the merits. The whiteboard was just to keep track of what elements of the charge Tom Bradley had actually met. So it had to do with the facts that were presented to prove the proposition, and the witness. Right. The facts and the witnesses were personal firsthand knowledge of the matters they're testifying to. So it's such as that he had a that he believed he was required to pay taxes. And so they wouldn't allow it on that. Even when he removed part of the statute, they would not allow it, because if it look, anything that tends to help that helps the defense in a tax case, the judge isn't going to allow it. That's just not the way it works with tax cases.
Right. But the point is that they go to extreme measures in order to make sure that you can't get anywhere with them, and that you can't get an acquittal, or they won't dismiss the case. It's a very difficult situation. So the only thing that really trips them up is that facts question right at the beginning. That's what trips them up the most, and that's what's the most. Can't be afraid of using it. A lot of the guys are afraid of using that thing, and that's about the one thing that really gets a lot of traction. That, along with your objections on the grounds of relevance. Those are the two things that are extremely important. And if you don't have that going for you in the case, you're going to lose it.
Well, yes, objection on relevance is very important, and also at least as important as that is facts not that assumes facts not in evidence.
Exactly. Exactly.
See, when you or I, when anyone is in court putting on what they call a case, so let's say the prosecution is making their case, the prosecutor has an obligation to do it in a proper logical fashion, just like we have to do that. You have to establish the relevance of what you're presenting. And if you can't establish the relevance, then it should not be admitted. And that's what they do to us all the time. So what they'll do is they'll put the witness on the stand, and they will not sustain our objection that the witness lacks personal firsthand knowledge. They just won't. They'll just say, you could bring that out on cross-examination. Damn, we're at the top of the hour break. But they will also, all right, well, we're going to talk about these objections when we get back. Let me mute you up. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network, and streaming live on my YouTube channel. Again, it's the top of the hour break for a radio broadcast. So we will be back in about 5 minutes. So smoke them if you got them. Yes, welcome back to the No State Project, second of 3 hours of Anarchy Radio. Anarchy, of course, no rulers. There's rules. We just want to see that the basic principles of right and wrong apply to everybody instead of a privileged class that does not have to, and where the rules don't apply. So this is where example I gave of this piece of garbage, where he reported in the last segment where he, Pennsylvania, for serial rapist abusing his his office is one, it's a one long abuse, but no jail time for serial rape, a law government. So Bill Higgins, 44, you piece of garbage, you see any jail time. So it's good to be one of the king's men. So, but welcome back, everybody. Talking with Al in California. We're talking about how it's necessary to have relevance for what you're trying to submit and what you're trying to argue. And that when you start making your case and you're calling witnesses or you're asking questions, it's not supposed to be in a haphazard way. You have to actually, and you have to build a foundation so that's why you don't call certain witnesses before others, because you haven't built the foundation on which to do that. Because let's say you have a sophisticated case, let's say like the Manafort prosecution, you can't, let's say you have 100 witnesses. There's a reason why you're calling person A first. And the first few witnesses are going to set the foundation for the later witnesses. You don't just haphazardly call witnesses to testify about anything, because you have to build the case. There has to be a logical reason. There has to be relevance to why you're doing it. And again, relevance is a very, very, very narrow. I mean, it's very easy, low bar. The rule is any tendency to prove the proposition, which we're discussing now, is that if they don't have any evidence to prove part one of their proposition, that the laws apply, and then two, that we violated them. If they don't have any evidence of part one, nothing they present for part two that you had, your alleged violation, none of that's relevant and is not admissible.
That's correct. And those are the two items that need to be stuck when you're in a courtroom. You have to stick with that, and it gets difficult because you don't know what the judge is going to say here and there, but you have to hold your ground on that. Otherwise, you won't get anywhere with it. A lot of times you'll come up with a dismissal, or they'll move it forward and send you a dismissal in the mail or whatever, but they won't want to mess with you if you stick with it. If you don't stick with it and then you go to the merits of the case, before the authority or jurisdiction is established, it's going to be much more difficult to get a good result.
Yeah, and just for those, going to court requires work. You have to do the work. You got to do the role playing. You got to study. You have to know the principles, and it requires some work. I definitely, say you need to do that. But you could do everything right in court, and the judge just doesn't give a damn, because what's unfortunate is the judge is the one that's going to determine whether anybody, whether it's a plaintiff or a defense, the judge is the one that's determining, obviously, that whether something is relevant or not, whether a question is relevant, or whether a piece of evidence is relevant, or whether a witness is relevant. But the principle is pretty clear. It has to have any tendency to show, to prove a proposition is true. And if you can't do that, then it shouldn't be allowed. And if you can do it, it should be allowed. But what you have seen, what I have seen, what's been reported on this show thousands of times, is that gets inverted. Prosecutors don't have to show any tendency to prove the proposition. They don't have to show any relevance whatsoever. They don't have to actually put facts into evidence before they make it, before they build on that. But when we actually do that, then it's not allowed. It's right. Not allowed.
And the whole case is going to rest on the facts question on almost every issue. And I would highly recommend anybody who is interested in this is to completely read and review your book, Adventures in Legal Land, that I got in a jail cell back in I think it was 2004 in December, and I was reading it, laying on my back, giggling when I started reading it, because that changed my whole concept of how I was going to approach this case. I kept it. It got me to keep it really simple. Okay, and apparently I had a partial success, but that's better than nothing. And so I was able to effectively get some damage control.
Right, and so let people know you were acquitted by challenging the evidence. You were acquitted of one of the charges.
Right, of conspiracy. Yes.
Right, and how many years in jail could you have gotten in addition to what you were given?
Well, that would have been another 5 years.
5 years, and so you have a full jury acquittal.
You helped to save me. You helped to save me 5 years.
Well,
so but it was your book that kept it simple, and what was interesting about it was that I completely got the facts question, because I was already what I was doing. I was asking for the liability, which is I learned from somebody else on what is the liability. But when I read your book, it put it more in a more usable way for me, and so that worked out very well for me, because one of the questions or one of the principles you had in there was who, what, where, when, and why. Did I get them all?
That sounds right. The 6 honest men.
Yeah, you ask those questions. When was I? When did this law apply to me, or how does this law apply to me?
Yeah, and so we continue to talk about that, and when you go into court, and this is something we talk about on the show all the time. A lot of, unfortunately, everybody, the new people, it may come down to a cross-examination as having the only opportunity you have. And it may be that you can hit a home run on cross-examination where the judge and prosecutor walk right into a trap and declare the witness incompetent to give legal determinations, which has nothing to do with the questions that we're asking. And then they deny cross-examination. The thing is, if a judge is willing to do that, then we have the fix was in, and we're going to have to hopefully get it cured on appeal. And it really is unfortunate. But and then again, for appeal too, I'm sure you'll agree, if you can't win by showing a denial of effective cross-examination, but then you had no chance at all. Nothing you presented was going to change their mind, because that's one of the worst errors that they can commit. But it's something we have to, expect that they're not going to apply the rules evenly. Like I said, they invert things, so they let the prosecution get away with something with with not following the rule, and then when we do follow the rule, they don't allow it for us. You have to
right, and that's why the applicability of the laws is extremely important. And you got to stick with it and forget about the fear. A lot of people are afraid to do this for whatever reason. They don't have the confidence in it. And it's been my experience that when you use that and you use it effectively, the case will go away one way or the other.
Well, most of these cases, tickets we still get thrown out, and people we've been very successful getting these tossed out for various reasons, of course. But it's very important that the defense that we're using is rooted in logic and has been proven to be effective. We're up against the break, so I'll mute you back up again. We're here on the No State Project, second of 3 hours of Anarchy Radio. We got a lot to still get to. You can join me at 218-632-9399. Passcode is 2020 with the #. We will be back in just a moment, so don't go away. Yes, welcome back to the No State Project here on the Liberty Radio Network, LRN.FM, streaming live from my YouTube channel, which of course is No State Project. So if you're not subbed, get subbed today. Talking with Al in California. I'm actually in California myself this weekend. The show will be live on Wednesday and next week from the Fortified Compound in Mesa, Arizona. It'll be always nice to get back home. San Bernardino, not the nicest place in the world, and certainly not the nicest part of California. Actually, it's not too far from the nicest parts, Big Bear and Lake Arrowhead, just a half hour up the street. What can you do? But welcome back, Al. We're talking again about the merits of it. I want to make clear that when we're talking about the applicability of the code, that the laws apply and you violated them, that's not just a jurisdictional issue. That's a big part of it, but it also goes to the elements of the charge. And, so it goes to personal jurisdiction and it goes to subject matter jurisdiction because it is just a code violation. And something to keep in mind that we've discussed this on the show many times. There just seems to be some, one or two people that just can't seem to, let this go. When they claim to have power or jurisdiction over you, Al, what do they tell you is the basis or where that power or jurisdiction comes from?
Well, in my recollection, they don't say anything.
Well,
they don't say anything. They'll say sometimes, well, you and I had something going on at one time where the lady said the laws apply because the laws apply.
Yes.
Do you remember?
Oh, yeah, we've got that. It's a call to shame. It goes back a while, though.
Right. Yeah, that goes back a few times. I haven't done that. The last time I was in court was about 4 years ago, and I simply asked the facts question. That was the first thing out of my mouth. They called my name, and I just said, what facts do you have that show that the vehicle code applies to me? And so she entered a plea, waited 30 days to go to trial, and then she said she called the officer to tell him not to show up. This is your lucky day. And out the courtroom I went.
Nice.
Yeah.
Nice.
Yeah. So, but they won't tell you. See, they don't have it. And if they tell you something, it's not going to be coherent. It's not going to be responsive. So anything that happens in the case after that, in other words, they start the steamroll, you have to object to everything because it's not relevant because there are no facts that show that the vehicle code applied to me or whatever code you're talking about.
Right. I wouldn't get specific that way. I always try to stick to the Constitution, which is supposed to, because I did a whole video about this. They don't go out and say, they don't say to you, and they certainly don't put it in their documents that their jurisdiction is literally power. That it is their willingness to put you in jail and to hurt you. What they say is that they are doing it based on the Constitution, that their power to act or their jurisdiction is by the Constitution. That's why they'll talk about an unconstitutional act, right?
I've never had that happen, but how does the Constitution apply to me?
Exactly. But what I'm getting to is a pretty persistent critic just keeps going on and on and on and on and on and on and on that jurisdiction is power. No one is disputing that. I'm not disputing it. What I'm saying is that I get that they're criminals. I understand that. I say that several times a show. I get that they're just men and women with guns. I understand that. But the public relations, we are showing a contradiction between their action and the public relations. The public relations says that they have jurisdiction or power to act pursuant to what is given them in the Constitution, which is why we challenge that jurisdiction over us. Many say that whether it's legislative, all jurisdiction, which is power, flows from an authorization through the Constitution, which they say is supposed to apply to everybody. Why? Because they said so.
Well, they could have said, if I asked that question, the vehicle code, then they could say, well, this was written by the legislature of the state of California under the Constitution of the state of California, and then that of the federal Constitution of the United States of America. But they don't even say that.
Yeah, but see, I
don't even say that.
I think it's better to cut out the just because if we just go straight to the Constitution, you believe that your laws apply just because I'm physically in California. They say yes. I'm like, well, what evidence do you have to prove that just because I'm physically here, your Constitution applies? Because if you see them in person, it's like. And so what the Franchise Tax Board is great for this. What they'll do is they'll completely ignore your statement or your question rather about evidence that the Constitution applies, and they'll go to the Revenue and Taxation Code. Well, the Revenue and Taxation Code. So you say, oh, so your position is that the Revenue and Taxation Code is somehow evidence proving your Constitution applies and not the other way around. And now they're stuck. I said, your own form letters that you like to send out state that the authority, the jurisdiction for the legislature to write the Revenue and Taxation Code is directly from Article 13 of the Constitution. Now, why are you saying it's backwards? And usually what they'll do is they'll back off of that because they realize how stupid it is. Because you could just ask them, so how exactly does the Revenue and Taxation Code prove the Constitution applies to me? And
there aren't any facts to prove it.
There you go. There is no. So even if you wanted to play the code game at that point, it would still be fairly effective. Say, show me the section of the code that actually spells out that it's proving that the Constitution applies to me. There's no such statute. I wouldn't necessarily do that. I stick with the evidence and say, well, isn't it backwards? Isn't the Constitution the authority for the code? Well, yes. Okay, so why are you telling me that why are you telling me the opposite, that the code proves the Constitution applies? How so? How does that work? I tell you.
Well, that's backwards.
And even they will agree that it's backwards. It's similar to when a tax agent in Oregon told me that the 14th Amendment was evidence that the Colorado Constitution applied to somebody. And I said, but wait a minute. What doesn't that mean that from 1776 to 1864, none of the state constitutions at the time applied to anybody? Yeah. Well, we'll finish in the next segment. We're starting to get lined up with calls. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network. If you want to join me, it's 218-632-9399. And if you've got a problem with the evidence and the logic that I'm presenting and now we are discussing on the show today, give us a call. Present your evidence. So I'd love to hear it. But we'll be back, so don't go away. Yes, welcome back to the No State Project. We're actually at the halfway point, but we got a lot of stuff to still get to. If you want to join me, it's 218-632-9399. 218-632-9399. Passcode is 2020 with the pound sign. Looks like I'm going to have somebody, we got someone lined up that is here in the Inland Empire, as it's called. Maybe a better area than San Bernardino. Somebody here in the chat was in San Bernardino. They called it San Bernardino, but we'll see. We'll bring Al back. This idea, this is just it gets to using logic and reason, of course, Al. You have to know what the actual claims are that are being used against you and just challenge them. Just look for the evidence. Right. In a general sense, what we typically get is you'll get people arguing that the prosecution doesn't need evidence. They'll lie to you saying, well, jurisdiction's a pure issue of law, requires no evidence. Well, except for your physical location. Well, then it's not a pure issue of law. And there are still people out there that will say that, Al. They will contradict themselves that way. These are the type of people that would have you believe that a woman could be pregnant and not pregnant at the same time. It's a lack of critical analysis, but I think it's that combined with the fact that those who do exercise and use some critical analysis on and apply the principles of logic to these political ideas, this garbage, is the friggin' arrogance that people will come out with that, to oppose you when you make those statements or you challenge such things, it's definitely where people, the gatekeepers do not want people questioning these things. And if you do, they have to, put you down and say that you're crazy, you're a scammer, you're this, that, all because they want a particular narrative and they don't want people questioning it. It's the same thing with this, saying that, that you cannot ask a police officer questions regarding the claims he made before the stop, or during the stop, and why he made the stop, so that the police officer is determining on his own that the laws apply and you violated those laws. Oh, but my gosh, if you ask him any questions on that, all of a sudden, even if you're only asking for the facts he used to base his decisions on, all of a sudden you've got these people who are triggered saying, well, you can't ask him a question that requires a legal conclusion. And that's not what you're asking. But thank goodness it's just one or two thorns that just keep parroting the same stupid, baseless accusation. If you ask a police officer,
it's almost comical in its contradiction, isn't it?
Well, right. If you're like in a situation like you with taxes, if a IRS agent says the laws apply and require you to file a tax return, that is a legal conclusion. That is not a statement of fact. Right. And so when you and I or somebody goes and we ask questions on what facts led the agent to believe that was true. What did you base your decision on? And for someone to, like for a prosecutor and their cheerleaders here on my YouTube channel, well, cheerleader, to turn around and say that calls for a legal conclusion is not only dishonest, it is such a douche move. When you ask for somebody for the facts that they used to support a decision that they made, that they are then using against you, that is not asking for a legal conclusion. That is asking for the evidence that the determination was based on. And it's something that maybe this gets to the fear that people have of making these challenges, because they know the judges and prosecutors don't like this. So what do you do, Al, when you're in a situation? I think there's definitely cause for concern here because of people going to, being threatened with contempt, but it has to give a normal person pause that the judge and prosecutor will both lie in open court shamelessly to your detriment. So I understand that people are concerned, but it shouldn't change our defense if we're going in. It shouldn't make us be less effective in court and ask these questions.
When I was learning to fly, we had a saying that it only hurts on impact. And when you're in a courtroom, you can't let that bother you. You have to put it out of your mind and stick with the program. Whatever plan you have to stick with it as much as humanly possible. Oh, I said human. Anyway, as far as possible, because they will do all of these different things in the courtroom to distract you away from your point. So what they'll do is they'll say, well, they'll say things like anything else. And I said, yeah, how about providing me the facts that show that the Constitution and the code applies to me?
Well, yeah, show me the evidence you relied on when you made this
Show
determination.
The evidence, yes.
Yeah, right. Now, I shouldn't do this, but this one keeps pointing out that opinions are governed by Rule 701, the evidence code. Well, one, that only applies to us when we're trying to ask for facts. And it's something that she just doesn't seem to get. When you ask for the facts that the police officer's determination of probable cause, that the laws applied and you violated, when you ask him for those facts, you're not asking him for an opinion. You're asking for the thought process that he went through and the fact, what he based his prior statement on. It is just, it is beyond the realm of stupidity to keep saying that when you're asking for the facts that a determination made at the stop was based on, that you're asking for his opinion. It is dishonest. It is a misunderstanding of the rules, and it's just garden variety trolling at this point. So it is. I'll say it again: the competency and credibility of any witness is up for grabs and is relevant on a cross-examination. If the police officer, or let's say a tax agent, determined that the laws apply to you, how he came to that determination is relevant for a cross-examination. And if you ask him if he made that determination, it's not that you're asking him to give a legal conclusion in a general sense. What you're doing is asking him to confirm that was a statement he made, during the administrative process. The idea that they can make these legal determinations and you can't ask them the basis of those determinations, it's just, and it's not part of a effective cross-examination. It's just stupid. Look, and I'm not saying for a second, Al, that doesn't mean that the judges are all of a sudden go like, oh yeah, you're absolutely right. The prosecutor should be sanctioned. You didn't ask him for an opinion. You asked him for the facts his claim was based on. I'm going to allow it. That doesn't mean they're going to do that. They're criminals. They are going to look. The judges are going to back the prosecution's lie, no matter how outrageous it is. And every time we go into court and that happens, it's just more evidence. As far as I don't know if you remember one time that's ever been reported out when we asked what facts they relied on to prove their contention or their claim that the laws applied was based on. Only one time, and it was in Canada with Germain, that they were allowed to answer the question.
Right.
Every other time they were declared incompetent to make legal, to give legal conclusions, even though that's not what you were asking the witness to do. Right.
Well, the big thing with these governments is that they assume that they have and I believe this too, that they assume that they have the power over us, but there aren't any facts to support it.
Right.
And so there is a thing called right and wrong. There is a thing called morality, and without the proper morality in life, nothing good is going to come from it. So is it, you have to ask yourself in a tax case, is it moral to have somebody work and then take?
Well, hold on. We'll have to finish that. We'll have to finish it because I'm sure they can't hear you. So we'll finish that in the next segment. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network, streaming live on my YouTube channel, No State Project. We'll be back and finish with Al talking about the moral implications of it in just a moment. So don't go away. Yes, welcome back to the No State Project here on LRN.FM and on No State Project, of course, on my YouTube channel. I'm talking with Al in California, who got a full jury acquittal, challenging the evidence that is supposed to be supporting the prosecution's claim, say probably 5 years in prison. So I'm glad I was able to help in some way to do that. And now you were talking about how there has to be a moral underlying principle here, or morality has to underlie all this.
Right, and this is something that I really hadn't thought about at the time. But when you when you really think about it, I've been doing a lot of study about natural law and things like that. Is the principle of do no harm, or do unto others like you want to have done unto you. And it's obvious that if you steal something from somebody, that is a theft and that it's wrong. Okay, so if a man does labor and he gets paid X amount of dollars, he is entitled to all of that money, whatever it is he's being paid, whether it's in other items or cash or whatever. So where would the state get the authority to steal that money? That's what you see. In other words, that's probably why they don't answer the facts question, because they know they can't. There's no moral obligation for anybody to pay them. And the way the government is now, it's so evil that it's probably more moral to not pay him anything.
Well, absolutely, it's more moral. In fact, you would have moral justification to use whatever force is necessary to stop their aggression. I'm not saying go out and necessarily and do that, but just as far as the morality of it, or the ethics of it. Obviously, if somebody is trying to hurt you, you have self-defensive force is always justified.
If you remember Mike's case back a few years back, there was a juror sitting in the jury box there, and she had her Bible, and the judge asked her something about that, and then he came back with it, said about the court proceeding that there is no moral component to this, which I thought was startling. That was a startling admission. I was sitting there with Mike's wife in there, and he says, there is no moral component to this. Well, excuse me, we all should be living on good moral principles, because that's how we get a good life. And if we don't have good moral principles, everything goes to shit.
Yeah, and there are actually court cases that contradict what that judge said, because and even if there wasn't, the fact, how do you determine whether something is fair if you don't have a basic moral principle governing of do no harm? How do you determine fairness? Is it fair to treat everybody bad? Well, according to some
if somebody
judges,
works and then somebody comes along and takes their money, that's stealing. Anybody knows that.
Well, sure.
How can somebody else take the fruit of somebody's labor and take it away from them after they worked for it and they earned it?
Forcing people, and even easier. If I forced strangers to give me money, I'm a criminal. And so that's why I asked the same thing of these actors, pretending to be government agents. I say, if I acted in the same manner as your organization and I forced perfect strangers to give me money, would you consider me a criminal? Like, well, hell yes. Right. There you go. Then your organization, which you get men and women that force strangers in a community to give you money, you're just as much of a criminal as I would be. That's the way, and it is the mental gymnastics that people put up. It's the trying to say, and they'll tell you, I've got call of shames with this. They'll say, but Mark, we have the law on our side. Where is your proof?
there is no man-made law that can override the natural moral order, if you want to call it a moral order. The morality is there for everybody to know. We all have a latent knowledge. It's just a difference between right and wrong. Okay, and taking somebody's money after they worked for it, a certain portion of it, is wrong.
Yep.
That's stealing. Now, if that person wants to donate to that particular organization, they can do that.
Yep.
Because if it's moral for the state to do that, then it's moral to have a slave system. And that's basically what the income tax and the government is basically an organized, very large slave system.
Yeah, it's a criminal organization. I know, I can hear it now. There's no such thing as an organization. It's just people. That's why I said they're just men and women forcing us to pay them. But as an organization, as an organized group of men and women, it is criminal in nature. So absolutely. And you know, everything is to try to get around that. It is to cover that fact up. That's why I used to use the old analogy of the whalers, where they go out and when they see a whale in the distance, they would throw a barrel or something in the water, and the whale would attack the barrel. And while he was being, you know, his attention was that they were free to kill the whale without risking having the whale destroy the boat and killing them. And so what's called law and politics, that's the barrel. So we just keep butting our heads up against and arguing their laws being unfair instead of saying, oh, wait a minute, these guys are trying to hurt us. They're criminals.
Maybe we should be asking what moral authority, what facts do you have that you have the moral authority to exercise over me?
I think the two questions that, you know, set the stage and do it very effectively. If I was to operate in the same manner as you and I force strangers to give me money, would you consider me a criminal? That's the moral question. The other thing is, I know that you operate under the presumption of find physically in California. Evidence, if any, do you rely on to prove that?
There isn't.
Don't buy for opinion. Can details apply? Every day, only the judges and they apply ultimately in a court case. But outside of court, it's not one of these things like the Franchise Tax Board trying to pull on me. Well, I'm not a judge. I can't say whether the laws apply. But you're doing it every day. You just don't like when the fact that I confronted you in a question you can't answer. And that's the idea.
And it's the morality is extremely important in everything. You think about the guy who's in the military, and he's given orders to shoot a family of 5 in Afghanistan. So if he lifts his weapon and wipes them all out, is the man a murderer?
Well, there was the myth of the innocent civilian who went through the same kind of ethical dilemma there. He has unless there's a gun, you know, unless they say, you know, what, it's still, there's no right or wrong to that. It's something that I believe they're both morally culpable.
The way I see it, if those people were not any threat to him, he would be a murderer.
Yeah, but the one who ordered him to do it would be, you know, culpable, you know, liable also.
Yeah, but the one who did it is the biggest responsibility, I think.
Probably,
I mean, that would be an opinion.
Yeah, it's a matter of degree, but they're both they're both certainly.
If people would look to morality, there would not be anywhere near all the problems that we have. There wouldn't be any wars. You know, there would be scuffles and conflicts and things like that. But I mean, the whole world would be a lot more peaceful if there wasn't any government. Well,
that's true. And the problem that we have, I think, is that people are looking at legal and illegal as opposed to right and wrong. And right and wrong is very easy to decide. I'm up against the top of the hour break. Hey, Al, I appreciate the call. I got to let you go.
Okay.
Definitely be more active, and hopefully we'll talk to you again real soon. My name is Mark Stevens. We're at the top of the hour break. So we're going into the third of 3 hours of Anarchy Radio right here on the Liberty Radio Network. And when you say that X law applies to somebody, or this written instrument applies to somebody, you need evidence. And you can't excuse that and just negate all principles of logic because you can't produce the evidence and you just want to make an excuse. So anyway, we'll be back in just a few moments here on the No State Project. Don't go away. Yes, welcome back to the No State Project, live from the fortified compound in San Bernardino, California, for this third of 3 hours of Anarchy Radio. I'm also streaming live on my YouTube channel, No State Project. And you want to join the big show, it's 218-632-9399, 218-632-9399. The passcode is 2020. You can also reach me on Skype, but please instant message me first at Frank Rizzo 3. That's Frank Rizzo with the number 3. And of course, anarchy being an absence of rulers, we want rules. We need rules based on the moral principle of do no harm, which has proven to be a pretty effective way to live your life. You know, we don't want to be harmed, so to be consistent, we don't harm others. It's just really that simple, and we do understand that by the time we're 4 or 5 years old. We do understand we don't want to be hurt. Consistency demands we don't hurt others. We don't need religion. We don't need laws, political laws to understand that. It's just basic common sense. It's self-preservation, and to be consistent, we extend that to everybody else. That's it. Is it a human construct? Yeah. Does that mean we throw the whole thing away? Well, doing heart surgery, all that information is a human construct. Does that make it bad? Yes, morality is human, but it's based on objective things. We don't want to be hurt. Self-preservation. Most species have it. So we extend that to others. I want to get to the calls. He's been very, very patient. We have area code 951. You're live on the No State Project. What's your name and what part of Southern California are you calling from?
It's Home Bumming It. I'm over in Riverside right now.
Home Bumming It?
Yeah.
Okay.
That's my handle online.
And you're in Riverside?
Yeah.
Yeah, okay. I drove through that last night on I-10.
Yeah. You got to go to San Bernardino from the east. You go through 10.
Yeah. So what's going on today?
Oh, man, I've been in court like 4 or 5 times so far already, and I haven't even gotten to any witnesses. The evidence, I went ahead and I put in Brady requests and demurs right away. Let's see. The first time they go ahead and they try to get me to sign paperwork for a public pretender, and I, won't sign anything. They tell me, well, you have to. And it's like, what are you going to do? Deny me due process if I don't? Come on. So.
And wait, what's the charge again? I'm sorry. What was the charge again?
Oh, sitting on the sidewalk.
Okay, but what's the actual charge?
904 point. Let's see.
But what is it actually? It's not just sitting on the sidewalk. Is it a trespass? Is that?
No. It's just sitting on the sidewalk. It's literally just sitting on the sidewalk.
And this is in Riverside?
904.1.
And
RMC.
Wow.
Yeah.
Holy
so
cow.
I did my paperwork right. Otherwise, they didn't dismiss it. They're not ignoring it. I filed it with the clerk's office. Yeah. And so they're not denying it. I'm sure they would have if something was wrong with it. But, yeah, the charges are for sitting down on the sidewalk.
Okay, and you filed the demur?
904.400D1.
Okay, and did you file the demur and a discovery request on this?
Yeah, I filed a demur, filed a discovery request. That's not the only charge. That's just the main charge. They got, riding a bicycle on a sidewalk, sitting down on the sidewalk. I got 2 charges of that. 20% of the people they're arrested in LA are for sitting down on the sidewalk. It's something that they do for people that they consider to be homeless. So, yeah, well, it's being outdoors is a crime.
So this actually did this happen in LA?
No. This is Riverside. I got 2 more tickets in LA.
Gee, what?
Let's see. Yeah, one for, or two more for sitting down on the sidewalk. No pedestrian shall sit, lie on sidewalk. No. Everybody goes ahead and can't seem to believe that you could get tickets for sitting. It's a misdemeanor charge too. That's what's tripping me out. So the first time I went, they went ahead and tried to get me to sign everything. I refused. Then the second time I went, they tried to get me to sign paperwork requesting for me to go ahead and represent myself, and I wouldn't. I refused to sign that. The judge finally said, "Well, he said, yeah, you can take that with you. We'll go ahead and extend it another 30 days. Come back, and you could ask whoever you were asking, for legal advice to, whether or not to sign it. But I won't. Last time they even tried to get me to sign a continuation, I wouldn't do it because the city attorney didn't show. They went ahead and they had the county attorney stand in for him, and then I got ticked, and the judge wanted to postpone it till later, and I objected and told him, hey, me and my mother been here all day. The guy doesn't even show up. What's going, dismiss, and he goes, well, I'm inclined to move to trial, and the judge has been pretty decent the whole time up until that last point where I think his mask slipped. He got kind of ticked at me. But, yeah, it's the charge of sitting down on the sidewalk. It's a misdemeanor.
Wow. I got to tell you, that's another, California is literally burning right now. There's some of the largest fires in California history. And they're arresting people for sitting on the sidewalk. Wow. But just
20% of all arrests in LA County. I mean, that's just that county.
That is wow. Yeah. Well, get your priorities straight there, guys.
The sanctimony of poverty and the bigotry, or the sanctimony of wealth and the bigotry of poverty seems to go.
Well,
universal.
Well, yes, people with it's always going to be a war against the people who don't have a lot of money. It's always it's always that way. Okay, but they always get much harder with these things because they're easy targets. Because even cops who are whistleblowers, people who are poor are easy targets because they're not going to be like like that swimmer who raped a girl. Brock, I think it was, because there was one whistleblower in Baltimore that said to specifically go after people who don't have a lot of money because they can't hire lawyers, and that's why they're easier targets. And that's that. These
they can't print out paperwork or anything.
Yeah, they go after the easy targets. So just because they haven't made a ruling on the demur doesn't mean they won't just at trial say, and end it. But how long has it been since you filed the Brady request? The discovery.
Oh, well, apparently I haven't. I need to subpoena the city attorney, even though we talked about it in court, and the courts accepted the demurs and the Brady requests and everything. And so my next.
Wait a minute. What would you have to subpoena the prosecutor about? Subpoena the evidence? Or subpoena them personally to answer questions?
I don't know. That's just it. I went ahead and I gave the city attorney the paperwork at his office, which is 2 blocks away from the courthouse.
Okay, hold on just a moment. We're up against the break. So just hold on a second. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network, and also streaming live on my YouTube channel, No State Project. We will be back with Home Bumming It in Riverside, California, where you can get arrested for sitting on the sidewalk. No joke. So we'll be back in just a moment. Don't go away. Yes, welcome back to the No State Project, live from the Fortified Compound in San Bernardino, California, which is currently on fire. And I think in some areas of the East Coast, they're actually getting ashes and smoke from some of these because they're huge. They're bigly huge. We're talking with Home Bumming It, and he's Home Bumming It in Riverside, California. Not currently on fire, as far as I know. But I don't think. Well, you know, you got the San Bernardino Mountains right here, which they have been ablaze many times. But we were talking about. So you don't know exactly what's going on. Why the judge is saying you have to subpoena the prosecutor?
No. The prosecutor, the city attorney, went ahead and told me that I have to refile with him or give him notice or something like that. And I was like, what? I don't understand that. They did go ahead and they gave me 3 DVDs with video footage from the vehicles, but it's like I'm not even on the DVDs. And they have one DVD where the cop is harassing me for sitting down on the sidewalk. It shows the guy right across the street sitting down on the sidewalk. You know, no big deal. The one video has me riding my bike on the sidewalk, and that same video shows 3 other people riding their bikes on the sidewalk. So I'm being targeted. You got to understand this. I went ahead and I participated in the Occupy movement out here at Riverside, and ever since then they've just been harassing the hell out of me. So
okay, so the cops kind of know you. So when you got these 3 DVDs, did the prosecutor, were they specific regarding what evidence they rely on to support the police officer's claim that the laws apply and you violated them?
See, that's just it. I haven't even gotten to that. I mean, my first, I went ahead and so far I've been able to ask a few questions. I've established that it's not a court of record. That's Department 22. It's not a court of record. The judge actually specifically said, you know, when I asked, he said, well, has anybody given you any evidence? And I said, no. I mean, you know, I'm waiting for it. And he goes, well, they haven't given me anything either. I was like, so, you know, the judge's constantly asking me for a plea. And I'm like, what evidence? Where's the evidence? You know, show me some evidence. Give me something.
Okay, so are you putting in terms like the video I have, what I recommend that I intend on pleading guilty? Does the prosecution have facts that to prove that there's personal and subject matter jurisdiction over me? I'll plead right now.
No, I haven't done that yet.
You gotta. I think it's better to frame it that way, so that. Because at some point in time, if you keep doing it that way, he's been very patient on. Most judges will just say, well, I'm off on goal, and I'm going to plead not guilty for you, because they take it that you're refusing to plea. So I would say if you go in there, don't give them that opportunity to do that. What I recommend, what I do is I intend on pleading guilty. Has the prosecution submitted facts to prove that, you know, personal and subject matter jurisdiction, or just say, do they have any facts to prove jurisdiction over me?
Yeah. Well, I got one question out, which was, do they have, what gives them standing in court to go ahead and prosecute me? And the judge said, well, it's his job. You know, basically they have it's their jurisdiction to go ahead and enforce rules, regulations, laws, whatever, you know, and their office gives them the standing.
Their office?
And
so that's why it's better. It's better to ask a leading question. What facts, if any, prove that just because I'm physically in California, that your laws apply? You want to. That's the prosecution's main claim, and so you want to just hammer away at that. What you did,
I haven't even gotten there yet.
Okay, well, you need to do the role playing with the script on the Skype chat. So you get me a Frank Rizzo 3, and we can help you out with that.
Oh man, I tried that, but every time I get on Skype, they want money.
Not if you contact me. If you contact me at Frank Rizzo 3, if anyone is and in this way, if I put you in a chat and somebody wants money from you, you tell me and we will permanently ban that person, because I've not heard that.
No, but
before.
No, that's not what I'm saying. I'm saying Skype won't even let me contact you or send you a message without going ahead and requesting money to be put in some Skype account or something like that. I don't really know what's going on.
No, for you to contact someone on a Skype in call. So if you want to contact another Skype member, you don't need to pay for that. You only have to see. I have on Skype. I have a phone number that's on the website, the 602-635 number, and I pay a little bit every 3 months for that, and that gives me well, that's in addition to if you want to call phone numbers, regular phone numbers. So if you want to call a bureaucrat, that you have to have money. But just to contact me or the chat, to text, or just to contact and call someone who's already a member, no, there's no charge for that.
I'll try it again. But yeah, I just haven't even gotten to the point where, I mean, no police have shown up to go ahead and testify. I haven't gotten a chance to really ask them anything. The last time, so far, it's been all here, sign this, and only the judge is responding to my questions. It's not like the prosecutors are saying anything in court. So, it's just I don't know why they're taking so long to do this. That's what's killing me.
Well, if you've effectively demurred to it and you're showing that they don't have the evidence and they can't produce the evidence, they could just be running the clock on you so that they can dismiss it for violating the speedy trial rule. So that's happened a bunch of times before. So as long as you haven't asked for a continuance, if it goes past 180 days and they have from the time that the ticket was filed, and they haven't brought you to trial yet, then yeah, they can denial of a speedy trial, so they kick it out on that. So this way, everyone gets to save face. And hey, it's not that we didn't have the evidence to crush this guy, but we have a busy office here. This is just sitting on the sidewalk kind of deal over here. This is not a big deal. So they don't have to actually admit it would even discuss the fact that they couldn't make their claim. They couldn't support their claim. That could be it.
Yeah,
how long has this been going on?
From giving more tickets.
Well, you're going to have to. Well, don't sit on the sidewalk and don't. So whatever it is that they don't like that they're targeting you for, I would avoid doing that. And if at all possible, do what so many other people are doing. Move to Phoenix. Yeah.
It's hotter over there, man. I can't take it.
Except for this past week, my friend, the humidity does not usually go above 10%. So if you've ever see, the only people who think it's funny and a joke that it's a dry heat have not experienced Austin or Houston and compare that to Phoenix. Phoenix, when it's 115 and 8% humidity, is nothing compared to Austin at 185% humidity. So big difference there. I've got to put you on a brief hold. We'll be back here on the No State Project in just a few moments. You want to join me in the last segments, you can do so at 218-632-9399. Yes, welcome back to the No State Project here on the Liberty Radio Network, LRN.FM, streaming live from the fortified compound in San Bernardino, live on my YouTube channel, No State Project. And want to bring back Home Bumming It in Riverside. We're getting low on time, so I'm going to try to get some other callers. But did you have any questions? Any other questions?
Well, I was thinking, what do you think about this? I just go ahead and I force them and plead not guilty to all the charges and see what they do. Because usually they just go ahead and drop them at that point.
I wouldn't do that. You know, if anything, you know, how long is it? This is what I wanted to ask before the break. How long has it been since, when did they file the original complaint against you?
Well, I got one complaint from 2016. One complaint from
2016.
Yeah, 2016 was one for riding my bicycle on the sidewalk, and that was after. That was just the city attorney just brought it up in court when I was there, and then this filing for sitting on a sidewalk was August 2017.
I would, and as long as you did not ask for a continuance, then I would file.
I only did it once.
Then you can't do it. Did you do it on both cases?
Well, it's just more like of scheduling it for the next appearance kind of a thing. Well, I didn't,
Okay. You can't do it on the 2017 charge because asking for continuance waives your right to a speedy trial. They could take as long as they want. Just real quick, Justin, you made a request. Just post it again because there's a lot in the chat and I'm not always watching it. So, Justin, please put your request in again and I will address it when we get a moment. What I would do is I would file a motion to dismiss for prosecutorial misconduct, in that the prosecutor was arguing without evidence and didn't respond and provide the evidence with the discovery, and is relying on witnesses that don't have personal firsthand knowledge of the matters that they're testifying to. And if you're worried about time frames, you could call the clerk or go down there and find out what day motion day is, and ask the clerk to schedule the motions for motion day that you want. Do you want to have a motions hearing?
Motions are Fridays.
Okay, well, then have them get you on the docket.
Go ahead and file say it again. What was that? Motion dismissed based on prosecutorial misconduct?
Prosecutorial misconduct.
And that's, what would that be? 3.1, Rule 3.1?
I have a motion. I have a template for that. I base it usually off the Shaw case. California has different numbers on their rules, so it's not 3.1 there. So I just basically go with the Shaw case that prosecutorial misconduct is arguing without evidence. Okay.
And I tell you, I put a Google alert on my Google account or my Gmail account for prosecutorial misconduct. There's not a day goes by you don't get three new cases of prosecutorial misconduct.
Did you just say Dago?
No.
You just said a day.
No, I said.
Okay, you said not a day goes by, and okay, it was just a silly joke.
Not a day goes by.
Yeah, you said Dago. Okay, end of call. All right. Well, contact me off air, and I can get you a copy of the motion to dismiss for prosecutorial misconduct, and then get that scheduled.
If I can't get you on Skype, I'll email you.
Yes, sounds good. All right, appreciate the call.
All right, man.
Thanks. All right, we're going to get to Sean in New York in just a moment, but Justin's asking what happens if what happens if you say who is the claimant? What happens if a person asks who is the claimant? They'll just say the state. They'll say the state of California or whatever happens, wherever you happen to be that they're charging you. That's quite different than asking if there's evidence of a complaining party. I don't think we have enough time typically to go through that. So over the years, I find that it's unnecessary to do that. I rather go right for the throat and start hitting them where they breathe. Where's the evidence to prove the claim that there's jurisdiction? And again, jurisdiction is not a pure issue of law requiring no evidence. I've said this. Anybody who says that, I don't care if they're lawyers. I don't care if they're law professors. They are lying to you. That is not true. Jurisdiction is not a pure issue of law. The applicability of the law is not a pure issue of law. Because even if you say, well, the law says you have to have a driver's license to drive. Is so-and-so required to have a driver's license? Well, you have to see if they're driving. That's a fact. There are pure issues of law, but jurisdiction and the applicability of a written instrument are not pure issues of law. That is what you call a classic douche move for someone who relies on a prison system, who has no evidence, and they want to try to trick you into thinking, I'm somehow special and my arguments are different. I don't need any evidence to support my claim. I can just say that they apply and then turn around and say, because of what I say applies, because I say these things are laws and that they apply to you, because I say that, I don't have to prove it. No, that's just a classic douche move. And other thing I wanted to get into, because it was California, something very important. It's not 602 in California for personal knowledge. And it's really specific here. It's 702 in California. So if you're in California, I want you to remember this. Subject to Section 801, the testimony of a witness concerning a particular matter is inadmissible unless he has personal knowledge of the matter. Against the objection of a party, such personal knowledge must be shown before the witness may testify concerning the matter. If a police officer is testifying that the laws apply and you violated them, they have to have personal knowledge of that. And Abba Fungul saying, oh, you judge. No, if the prosecution calls a witness who's testifying that the laws apply and you violated them, bam, they have to have personal knowledge of that. And no, it's not for you to bring it out on cross-examination that they don't have personal knowledge. It is for the witness to put the evidence on the table. Such personal knowledge must be shown before the witness may testify, not after on cross-examination. So I'm catching myself. Of course, it's not clear to everybody. It's only clear to those who want to be fair and honest and have an open discussion on it, instead of just saying, oh, the rules, no. Logic doesn't apply. This is the courts. Only power applies. Yeah, but we're bringing out contradictions to show it's not fair, because they're not saying our jurisdiction comes out of a barrel of a gun. They're saying their jurisdiction comes from a written instrument nobody bothered to sign. Big distinction there. So he's been patient. Go to Sean in New York. Sean, welcome back to the big broadcast. Sean. Okay. We will mute Sean back up. And we'll keep discussing this. This is really, really important. And all that's done when, all the mental gymnastics, it's just to try to convince you that they are somehow special, that the rules of logic and fairness and whatnot don't apply. And I can guarantee you, this is for the new people, I can guarantee that if after the judge doesn't enforce Rule 702 and allows the witness on the stand anyway, without a showing of personal knowledge, if you go ahead and try to get away with the same thing, the prosecutor will have an aneurysm screaming, objection, Rule 702, there has to be personal knowledge. They know damn well it has to be, but the judge is not going to hold the other prosecutor to that. Okay, my name is Mark Stevens. You want to join me? We got one more segment left, so I don't know if we're going to hear from Sean or not. But we got it's 218-632-9399, 218-632-9399. Passcode is 2020 with the #, and Skype is Frank Rizzo 3. Yes, welcome back. Listening to the No Stay Project here on LRN.FM and streaming live from my YouTube channel, No Stay Project. And somebody is at M Streetoff is asking, what's with Abafangul? Is that like an Italian or New York thing? Yeah, it's an Italian thing, Sicilian in my case. And I think that's the way because of the way I say it. It's a little different than the way an Italian would say it. But it is it's an Italian or Sicilian way of saying F you. So it's usually accompanied with this or this. Abafangul. So if a Sicilian or an Italian is doing this, that's the sign. That's like a sign language there. That's not a good thing. Not a good thing. And what do I say to people who think that jurisdiction is just a pure issue of law requiring no evidence except that your physical location, which about Fungul with that nonsense, because it's just so stupid. It is such a just an arrogance, smack in the face. It's a put down to your intelligence that you can say something that is contradictory on its face and expect that anybody with half a brain in their head is not going to notice and is going to accept you as some kind of scholar. Yes, you can say that a written instrument applies to somebody and it doesn't require any evidence to prove it's true. Oh, please give me a break. There's nothing philosophical about a written instrument. It's objective. It's real. And to turn around and say that this document applies to everybody and I don't need evidence to prove it. No, you're either an idiot or you're trying to put something over on somebody and you think that everybody else is an idiot because they're not going to realize how stupid that is to say that a written instrument applies to people just because you said so or because you're willing to hurt them. Well, this written instrument says you're going to do what I say or I'm going to hurt you. Oh, well, I guess you have jurisdiction there. So I'm going to try to get to some calls in these last couple minutes of the big show. We have Eric. I think this is maybe Justin. We have area code 814. You're live on the No Stay Project. What's your name? Where you calling from? I got nothing. I don't think, all right. We will mute that back up and we will unmute. Area code 732. This sounds like New York. Area code 732. You're live.
Mark.
Yeah, what's your name? Where you calling from?
Hey, Mark. My name is Justin Pont, sir. I'm calling in. Okay. Quick question mark. Any interactions with a S.B. Johnson, sir?
Say that. Any what?
Any interactions with a S.B. Johnson?
S.E. Johnson?
S.B. Johnson.
I don't know. No, I don't. Oh, Misty. No, I won't respond directly to. And I think you guys are wasting your time chatting. She's getting a real big kick out of making some of you guys crazy.
All right.
I don't even want to just, if it's an argument that's being made, we can discuss the argument. But as far as the person, I couldn't.
Yeah.
I don't want to discuss the person. But if there's a particular argument you want to address, I'm happy to do that. What do you got? Okay, I guess that's just not working out. He dropped off. So we'll try area code 814 again. You're live on the No Stay Project. What's your name? Where you calling from? Hello? Yeah, I mean I can hear you back there, but I can barely make it. I can't really it's just I can't make it out. And no. Okay, yeah, and real quick, no, I didn't hang up on Justin. The line dropped. I didn't do that. But okay, anyway, so in the last few minutes we got you here. What's your name? Where you calling from?
James from Pennsylvania.
Okay, I don't know what that's supposed to mean, but welcome to the show, James. What can I do for you today?
Well, it means that sometimes Pennsylvania feels like Kentucky, but
okay,
I have charges in New York, and I was wondering about how they operate ex parte, because when I was talking to the court clerk, he said that nobody else has to be there, just the judge. So I really want to kind of see if maybe I should try to hang him on that as much as facts being argued not entered into evidence. But just the
so
judge
they're saying, well, what kind
of
charge is this now?
It's a DWI refusal, obstruction of justice, tail light infraction, and they said I didn't have a license. I mean,
wow,
I do, but
you
didn't have one.
Now now did they say a prosecutor did not have to be present for trial, or just didn't have to be there for arraignment?
Didn't have to be there for arraignment.
Okay, well, I can, that's not a big deal. Some places, don't always have the prosecutor there. I think they need to be there if you're going to challenge, because I guess that's the thing. Most people don't challenge, so the prosecution usually doesn't have to show up unless they're going to make a deal. So I wouldn't. That's not an issue I would press. But I would file them. Have you filed the motion to dismiss and the discovery request yet?
Well, I went to go do it personally to get it on the judge's desk before Monday, but they refused to take my motions.
The prosecutor refused, or the clerk of the court?
The clerk. I went to go get them stamped.
And the clerk refused on what grounds?
Because I wasn't being represented by anybody. And I told her I was trying to make that determination, but I need to get these motions in. And then I asked for that in writing. She refused to give me that in writing, that she was refusing to take my motions.
You know what I would do? Just mail the damn things in, and mail copies to, of course, as you should, to the prosecutor, and they'll probably get filed that way. The idea that you have to be represented by an attorney to file paperwork is ridiculous. You don't have to. There have been people who defended themselves in murder trials. They didn't have to have a lawyer. So just another clerk being a douche.
Yeah, no, I mean, I took my own record of it, but it's going to be completely useless. Just wanting to know whether I'm operating without a person there to stand and be a claimant, because it would just be a cop right now. And they said that there will be a district attorney on the case if I were to go to trial or whatever.
Sure. Well, there has to be a DA assigned, because it's obstruction, so it's at least a misdemeanor. So this is criminal courts, DUI. It's not New Jersey. Even if it was, the fact that you have an obstruction charge there, it's going to be obviously it's going to be criminal. So there will be a pretrial procedure here, because you're in Pennsylvania or Kentucky. You're not in New York. So they have to be available, and someone will be assigned, should be assigned, to take care of the discovery. You send the discovery to the prosecutor's office anyway, whether there's somebody individually assigned or not. You always send a copy of the paperwork. Everything that you file, you send copies to the prosecution. So I would get that done as soon as possible.
Well, those charges are in New York, but I have different charges in Pennsylvania. I have the arraignment for this, the 20th, and then I have the arraignment for Pennsylvania charges. It's like I got arrested twice in like 10 days.
What the hell is going on here, James, that you're getting arrested so much?
I got arrested for taping in a public place. They said they gave me an F3 wiretap charge for videotaping police officers in a public place.
Haven't they learned that is perfectly legal?
I mean, I'm going to try to teach them. But, well, I don't even know if those laws apply to me anyway. So, well,
that's true. The fact remains that they have no grounds to charge you for recording in public and wiretapping, because videotaping is allowed in public. You can videotape the police. It's not a wiretapping charge. It's not even a case of where's the evidence that the laws apply. It's a case of they're not even charging you with one of their laws.
Well, they sat me in the police station, and they fingered through a code book for about a half hour until they could find a charge that they felt looked decent enough to stick me with. So they stuck me with that one.
Wow.
They gave me a defiant trespass for not leaving.
Well,
and they stuck me with that charge.
Well, videotaping police officers in public is not. The courts are pretty unanimous on this. It's a well settled law that it's not wiretapping when you're doing it in public like that. Videotaping police officers. So, what do you like? One of these cop watchers or cop blockers?
Well, I had to go. Well, it was at a post office, and then I had something happen at a post office, and they were standing there talking to me, and I was investigating a crime that they committed against me. because they stole my property.
Wow. Well, I would. We're completely out of time, so I've got to let you go. Contact me off air for more help, or if you have other questions at markstevens.net. My name is Mark Stevens. You're listening to 3 hours of Anarchy Radio right here on the Liberty Radio Network and streaming, of course, live on my YouTube channel, No State Project. Whoever we missed today, we'll get you on the Wednesday broadcast. And so till then, salud. That's one of them Sicilian things there, too.